near the crime scene on your way from your residence to, I guess, to lunch or to wherever you were going next? The crime scene or very near the crime scene on your way from your residence to, I guess, to lunch or to wherever you were going next?
Hello, everyone. I will be reading the latest motions regarding Charles Adelson, and the motions will be self-explanatory, so I'm just going to get right into it. This is a motion to relinquish jurisdiction to the trial court. The appellant, Charles Adelson, by and through undersigned counsel, moves the court to relinquish jurisdiction in this case to the trial court and alleges: 1. Appellant Adelson is appealing his convictions following a jury trial for murder, conspiracy to murder, and solicitation to murder. Appellant Adelson was sentenced to life in prison. Number 2. Appellant Adelson is one of several persons charged with the murder of Dan Markel. Prior to Appellate Adelson's trial, 3 other people were convicted of the murder of Mr. Markel. After Appellant Adelson's trial, but before his sentencing, another alleged co-conspirator, Donna Adelson, was indicted and arrested for murder. Number 3, at his trial, Appellate Adelson was represented by attorney Daniel Rashbaum, Esquire. After Appellate Adelson's sentencing, Mr. Rashbaum appeared as counsel of record for Donna Adelson in her case. Number 4, on September 11, 2024, the state issued a subpoena on Appellate Adelson for him to be a state witness at Donna Adelson's upcoming trial. Shortly thereafter, Mr. Rashbaum withdrew from Donna Adelson's case after the trial court questioned him about the conflict of interest that existed due to his current representation of Donna Adelson and his previous representation of Appellate Adelson, who is now a witness in Donna Adelson's trial. Then, on October 7, 2024, the trial court disqualified Donna Adelson's other defense lawyers from her case on the basis of Mr. Rashbaum's conflict of interest. The withdrawal of attorney Daniel Rashbaum became necessary when he engaged in a conflicted representation falling short of the ethical obligations for members of the Florida bar. Upon further consideration of the September 17, 2024 record and the in-camera proceedings with attorneys Daniel Rashbaum and Robert Morris, a sufficient ethical wall was not established. Thus, the conflict of interest involving privileged information or communications has been imputed to Robert A. Morris. Additionally, this case is rife with the potential for the same conflict as to Adam Commissar. C. Colker versus State, Florida 3rd District, DCA 2017. Unimputing a conflict seems as implausible as unringing a bell, unscrambling an omelet, or pushing toothpaste back into the tube. Florida are regulating Florida bar impose on all Florida attorneys an ethical responsibility to refrain from engaging in conduct intended to disrupt a tribunal and conduct which is prejudicial to an administration of justice. While the defendant retains a presumptive right under the Sixth Amendment to her counsel of choice, the right is not absolute. C. Wheat versus the United States, 1988. The presumptive right under the Sixth Amendment to counsel of choice cannot interfere with the fair and orderly administration of justice or the court authority to monitor and control the pace of litigation. See Florida, our General Practice and Judicial Administration Rule 2.545. That's 2.545, excuse me. Both federal and state courts have repeatedly made clear that the right to counsel cannot be manipulated so as to obstruct the orderly procedure in the courts or to interfere with the fair administration of justice. Bowman versus the United States, Florida, 1984. Florida Supreme Court holding there is no absolute right to a particular counsel where there's countervailing public interest in the fair and orderly administration of justice. The fair and orderly administration of justice cannot be maintained when conflicted counsel or counsel with the potential of conflict cannot meet the standard of serving as constitutionally effective counsel. See Colker, 649 Southern 2nd District at 252. In parentheses, explaining trial courts have an institutional interest in protecting the truth-seeking function of the proceedings over which they preside by considering whether the defendant has effective assistance of counsel, regardless of any proffered waiver. Furthermore, the danger to conflict-free proceedings was not cured by Daniel Rashbaum's withdrawal. Prior to the selection of jury, Charles Adelson filed a notice indicating his non-waiver of any conflict of interest with Daniel Rashbaum. Robert Morris then filed a response in which he advised that third-party counsel had been retained to resolve any actual or potential conflict of interest. In a reply to this response, Charles Adelson objected to Morris or a third-party counsel cross-examining him. The Third District Court of Appeal, when reviewing the disqualification of counsel in Colker, disagreed with the proposition that an actual or potential conflict could be avoided by having substitute counsel conduct the cross-examination of a former client. And this is 649 Southern District at 252, number 3. The Colker Court further explained the conflict arises from the past relationship and cannot be avoided by sectioning off portions of the trial. The potential for conflict would remain, as would the appearance of impropriety. Absent judicial intervention at this point, delayed to the fair and orderly administration of justice will be at risk of repeating itself. Without the establishment of a sufficient ethical wall and the fact that even third-party counsel cannot avoid potential for conflict, the court cannot permit Robert Morris or Adam Commissar to remain as counsel of record. Nor will the court permit this untenable situation to continue. Accordingly, for the above reasons, attorneys Robert Morris and Adam Commissar are disqualified from further representation of the defendant. Number 5. Against this backdrop, undersigned counsel believed that Mr. Rashbaum's conflict of interest also infected Appellant Adelson's trial. During the course of their representation of Appellant Adelson, undersigned counsel learned that Mr. Rashbaum represented Donna Adelson prior to the arrest of Appellant Adelson. Stated another way, Mr. Rashbaum previously represented a co-conspirator in the same or substantially related matter, and he had an actual conflict of interest during the course of his representation of appellant Adelson. 6, notably, Donna Adelson was listed by the state as a Category A witness in appellant Adelson's case. Subsequently, Donna Adelson was listed as a defense witness for trial. Ultimately, Donna Adelson was not presented as a witness during appellant Adelson's trial because she was removed from the defense witness list days before the trial was to begin after the state sought to interview her. Undersigned counsel assert that Donna Adelson's removal from the witness list was done in order to protect Donna Adelson's interests and against appellant Adelson's interests. For example, a witness that could have corroborated appellant Adelson's testimony was not called by Mr. Rashbaum. Hence, Mr. Rashbaum's representation of appellant Adelson's at trial, after having previously represented Donna Adelson, constituted an actual conflict of interest. As explained by the 11th Circuit Court in Appeals in Porter versus Singletary, and this is the 11th Circuit in 1994, an attorney who cross-examines a former client inherently encounters divided loyalties. Given the recent finding by the trial court in Donna Adelson's case regarding Mr. Rashbaum engaging in a conflicted representation falling short of the ethical obligations for members of the Florida Bar, appellant Adelson asserts that the same principle applies to Mr. Rashbaum's representation of appellant Adelson at his trial because attorney Rashbaum was operating under a conflict of interest based on duties owed to his former client, Donna Adelson, whose attorney-client relationship predated appellant Adelson's. Number 7. I'm going to skip the footnotes. Okay, sorry. Number 7, documents supporting the statements set forth in the previous paragraph are included in the appendix to the motion, and the documents establish the following. The murder of Dan Markel occurred in 2014. In 2016, the probable cause affidavit naming Sigfredo Garcia, Luis Rivera, Catherine Magbanua, appellant Adelson, and Donna Adelson as co-conspirators was released. In 2016, attorney Daniel Rashbaum was Donna Adelson's attorney for purposes of the investigation into the murder of Mr. Markel, as evidenced by his signature on the Adelson family statement. In 2022, appellant Adelson was charged with the murder of Mr. Markel. Mr. Rashbaum filed a notice of appearance on May 9th, 2022. Appellant Adelson did not validly waive the conflict of interest involving Mr. Rashbaum's representation of him at trial and Mr. Rashbaum's prior representation of Donna Adelson, who was listed as a witness by both the state and the defense. A review of the record on appeal establishes that a conflict waiver inquiry was not conducted by the trial court. For a waiver of conflict-free counsel to be valid, the record must show that the defendant was aware of the conflict of interest and that the defendant realized the conflict could affect. Sorry, that was part of the footnote. I'm going to go back to that. Next point. On September 22nd, 2023, Donna Adelson, Mr. Rashbaum's former client, was listed as a state witness for appellate Adelson's trial. Also on September 22nd, 2023, Donna Adelson, Mr. Rashbaum's former client, was listed as a witness for the defense for appellate Adelson's trial. In October 2023, Mr. Rashbaum withdrew Donna Adelson from the defense witness list in appellate Adelson's case after a hearing in which the state sought to compel Donna Adelson's interview. In October through November 2023, appellate Adelson was tried and convicted while represented by Mr. Rashbaum. In November 2023, Donna Adelson was indicted and arrested for the murder of Mr. Markel. In a November 2023 recorded conversation leading to Donna Adelson's arrest, Donna Adelson discussed advice she had received from Mr. Rashbaum regarding whether she would be able to leave the country undetected prior to being arrested for the murder of Mr. Markel. In quotes, "Look, we have to make a decision at some point. After speaking to Dan this morning and knowing what they're thinking up there, I don't know if we'll make it out on time. I really don't, because Dan said you might, or you might do all of this, get to the airport and they'll stop us. And that could happen. It could happen, I don't know, but it's worth a try," end quote. In December 2023, appellant Adelson, represented by Mr. Rashbaum, was sentenced. In January 2024, Mr. Rashbaum appeared as Donna Adelson's defense counsel for trial. In September 2024, appellant Adelson was subpoenaed as a witness for the state for Donna Adelson's trial. In September 2024, Mr. Rashbaum withdrew and/or was removed from Donna Adelson's case by the trial court on the eve of jury selection on the basis of Mr. Rashbaum's conflict with appellant Adelson. In October of 2024, the trial court, on its own motion, removed the remaining defense counsel for Donna Adelson on the basis of Mr. Rashbaum's conflict of interest and the lack of a sufficient ethical wall. Number 8, accordingly, in light of the foregoing, appellant Adelson intends to file a motion in the trial court raising that this conflict claim against Mr. Rashbaum, who represented appellant Adelson at trial while owing duties to his former client, alleged co-conspirator and listed witness Donna Adelson, to whom he continued to provide legal advice regarding her own involvement in this case while simultaneously representing appellant Adelson. Because Mr. Rashbaum's conflict of interest in Donna Adelson's case was just recently considered and ruled upon by the trial court, undersigned counsel submit that it would be in the interest of judicial economy to allow the trial court the opportunity to immediately consider whether the same conflict infected appellant Adelson's case. The trial court is uniquely situated to decide this issue, having previously presided over appellant Adelson's trial and now presiding over Donna Adelson's trial, and because the trial court was recently apprised of the conflict issues involved with these lawyers and parties. Number 9, appellant Adelson therefore requests the court to relinquish jurisdiction to the trial court for a reasonable period of time so that he can file a motion raising this conflict issue. Appellant Adelson respectfully suggests that it would be a more efficient use of judicial resources to address this matter immediately, because if the trial court grants the motion, then the instant appeal would become moot. Number 10, in State versus Meneses, the Florida Supreme Court considered the question of whether the pendency of a petition for writ of certiorari in the Florida Supreme Court arising from the affirmance on direct appeal of the judgment and sentence deprives the trial court of jurisdiction to consider a Florida Rule of Criminal Procedure 3.850 motion to vacate filed after the certiorari petition has been filed in the Florida Supreme Court. The Florida Supreme Court held that the trial court was deprived of jurisdiction to rule on Maness's motion, it's a tongue twister, Maness's motion to vacate while certiorari proceedings were pending in the Florida Supreme Court. However, we're going to skip this footnote. Number 11, we're going to go back to the footnotes and the appendix. Number 11, the remedy suggested in Maness's was followed by this court in Jefferson versus State. And this is Florida First DCA in 1983. In Jefferson, while the defendant's direct appeal was pending, the court entered an order temporarily relinquishing jurisdiction so the defendant could pursue a Rule 3.850 motion. The court stated that the following procedure applies when such relinquishment is granted. In Combs versus State, 403 Southern 2nd District 418, Florida, 1981, authorizes relinquishment of jurisdiction to the trial court when counsel informs the appellate court of an honest belief that there is an issue as to ineffective assistance of counsel. That opinion, as well as State versus Maness's 392 South 2nd District 905, Florida, 1981, same one as previous, appears to us to contemplate that the proper procedure to follow when such relinquishment is granted is to file a motion for post-conviction relief pursuant to Florida Rule of Criminal Procedure 3.850. If the trial court does not grant the relief, a new notice of appeal may be filed. And the original appeal may proceed if there are other issues, and it should be dismissed if they are not. As our order in this case stated, jurisdiction was relinquished for collateral proceedings. For example, for instituting proceedings separate from the trial and pending appeal. However, no such motion was filed. Instead, the trial court and the parties apparently relied on the allegations in appellant's motion to relinquish. While this procedure was not in technical compliance with our order, we entertained the appeal by treating the procedures below as having been conducted pursuant to remand for hearing upon an application for a new trial. See Antone versus State 382 Southern 2 District 1205, Florida, 1980, cited in Combs, in which the Supreme Court remanded for testimony in the trial court on application for new trial. Under Florida Rule of Criminal Procedure 3.600, B8, ineffective assistance of counsel may properly be raised as a ground for a new trial. The issue in this case, having been thoroughly aired before the trial court, is now sufficiently preserved and presented for our review, and the appeal from the judgment of conviction is carried over for that purpose. Okay, I believe that's part. Okay. See also Libby versus State 520 Southern District 2nd District 322, 322 Florida 2nd District DCA 1988. Accordingly, and this is in parentheses, accordingly we affirm the trial court's denial of appellant's Rule 3.850 motion without prejudice to appellant, 1, filing another such motion after his present appeal has been decided and has become final, or 2, as recognizes in Benessis, seeking an order from this court to temporarily relinquish jurisdiction to the trial court for the purpose of being heard on this motion. And that's in italics, so emphasis has been added. Wright versus State, and this is from 1984. The Rule 3.850 proceeding was conducted in the trial court while the plenary appeal was pending here pursuant to our express relinquishment of jurisdiction for that purpose. Number 12, more recently, this court found that the relinquishment procedure set forth above in Ferguson versus State, as demonstrated by the court's December 30th, 2020 order in that case, and Wall versus State, as demonstrated in the court's December 22nd, 2016 order in that case. See also Hatton versus State, case number, I'm not going to get into all that, March 4th, 2005, granting motion to relinquish jurisdiction. Crane versus State, case number blah, 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 December 6, 2016, order granting motion to relinquish jurisdiction. Sugini versus State, August 12, 2024, order granting motion to relinquish jurisdiction. Number 13, pursuant to Meneses, Jefferson, Ferguson, and Libby, appellant Adelson requests the court to temporarily relinquish jurisdiction to the trial court so that he can raise his conflict claim. Consideration of the factors set forth in Meneses and Jefferson established that the relinquishment is appropriate in the instant case. For example, the current direct appeal proceedings are not nearing conclusion, in quotes, as the initial brief has not yet been filed. Appellant Adelson's conflict claim is not frivolous, and undersigned counsel have an honest belief that there is a credible and good faith basis for appellant Adelson's claim. Moreover, appellant Adelson submits that it serves both the interests of justice and the judicial economy by having the trial court address appellant Adelson's claim at this time, since the conflict claim was just considered by the trial court in Donna Adelson's case. Number 14, certificate of counsel. Undersigned counsel have contacted opposing counsel, Chief Assistant Attorney General Tricia Meggs Pate, who has indicated that the state needs additional time to consider its position. Undersigned counsel will file a supplement indicating the state's position, or the state will file a response. Wherefore, for the reasons set forth above, appellant Adelson requests the court to temporarily relinquish jurisdiction to the trial court so that he can raise his conflict of interest claim. Now, there's a huge appendix that was attached to this and several footnotes that I'm not going to read, but I am going to open the appendix real quickly so you can understand. So we have a understanding of what the appendix is, and it's quite large. So let me grab that, be right back. Thank you for waiting. And again, this was the original motion and appendix from October 16th, so 10 days ago, that has been discussed quite a bit by YouTube lawyers. So the appendix, let me see if I did this right. Yes. Again, submitted with the motion by Attorney Upperman. And this is a very large appendix. It's 105 pages. We're just going to go through the index. So the first exhibit in the appendix was the probable cause affidavit, and that was for, let me see if I can see, for Catherine Medbanwa. Okay, so that was from 2016. That was in the appendix. That was the first. And while I was reading, you might have noticed page numbers A3, A21. These are the corresponding page numbers over on the right. So the first exhibit was the PCA, probable cause affidavit. The second item in the appendix attached was Adelson's Markel's accusation, quote, fanciful fiction, the statement that Rashbaum made, and this was from the Tallahassee Democrat. It was a press release regarding the involvement of the Adelsons in Dan Markel's death being called fanciful fiction by Daniel Rashbaum, which basically shows that he was representing everybody in the family at that time. The third exhibit was from May 9th, 2022, notice of appearance, written plea of not guilty and demand for discovery, and that was for Charlie. And so these are all documents we've seen before. Exhibit number 4 was the September 22nd, 2023 state's witness list as referenced in the motion. And then the 5th exhibit is the defendant's, Charlie's witness list, also as both of those included Donna Adelson as a witness. The 7th exhibit was state's stipulated motion in limine from October 20th. And then the 8th exhibit was Donna's indictment from November 15th, 2023. The 9th exhibit was a transcript of December 2023, the sentencing hearing for Charlie. Number 10 was January 8th, 2024, motion for substitution of counsel. And if you want to take a look at that, we can take a look at what that is, but that is for Miss Marisol, I believe, and then Rashbaum. The number 11 exhibit was on September 11, 2024, the witness subpoena for Charles Adelson. So that was when they subpoenaed Charles to be a witness in Donna's trial. The 12th exhibit was a transcript of the pre-trial hearing, September 17th, 2024. That's Donna's pre-trial hearing. And then October 7th, 2024, the 13th exhibit was an order disqualifying the defense counsel. We all remember that. So there's quite a few exhibits. It comprises 105 pages. So that was included with the motion. And I wanted to read the response. Let's see if I can get through it. My throat's a little sore, but let's see if we can get to the response because it's not quite as long. One moment, please. All right, and I am back now with the state's response to that motion. The state responded or replied 2 days later on October 18th. So that was 8 days ago from today. And this is, of course, the state replying basically to Ufferman. State's response to appellate's motion to relinquish jurisdiction to the trial court. Charles Adelson has filed a motion to relinquish jurisdiction to the trial court in Leon County. While Adelson's motion is unclear as to what specific proceedings he seeks in the trial court below, Adelson appears to be pushing pursuing a claim of ineffective assistance of counsel while his appeal is pending. The state objects to Adelson's motion to relinquish because it is procedurally barred, and Adelson has failed to demonstrate a valid reason to circumvent the normal procedures for post-conviction relief under Florida Rule of Criminal Procedure 3.850. First category is issues presented. Charles Adelson's motion presents two issues for this court to consider. First, can Charles Adelson pursue his conflict of interest claim while his direct appeal is pending? Second, if Adelson can pursue his claim during the pendency of this appeal, should this court exercise its discretion to relinquish jurisdiction to the trial court? Procedural history. A jury convicted Charles Adelson of first-degree murder, conspiracy to commit murder, and solicitation to commit murder. Attorney Daniel Rashbaum represented appellant Adelson during his trial. After Charles Adelson was convicted, his mother Donna Adelson was arrested and charged as a co-conspirator in the same murder. After this arrest, Rashbaum represented Donna Adelson in her case. Rashbaum told the trial court that Charles Adelson had waived any conflict of interest that might arise from Rashbaum representing both Charles and Donna. But on the eve of Donna Adelson's murder trial, Charles Adelson rescinded his waiver of conflict of interest. This led Rashbaum to remove himself as Donna Adelson's attorney in her murder trial. Now, Charles Adelson claims that Rashbaum's representation of Donna infected Charles Adelson's trial. According to Charles Adelson, his case should be relinquished to the trial court for some type of hearing regarding Rashbaum's potential conflict of interest. Adelson relies primarily on State versus Meneses and Florida in 1981, which said that appellate courts have the discretion to relinquish jurisdiction to a trial court so that a defendant may pursue a 3.850 claim. The state opposes this motion and asks the court to make Adelson follow the normal route of pursuing a 3.850 ineffective assistance of counsel claim. Adelson's conflict of interest claim should be handled as a post-conviction claim of ineffective assistance of counsel. Adelson's motion fails to explain what he would accomplish by having his case returned to the trial court. Adelson does not allege that a hearing is necessary to establish a claim cognizable as to this direct appeal. To further the confusion, Adelson's motion does not state that he's moving under any rule of criminal procedure. Instead, Adelson simply quotes old case law where appellate courts have relinquished jurisdiction for a defendant to pursue a claim under Florida Rule of Criminal Procedure 3.850. The only plausible 3.850 claim that Adelson could make on Rashbaum's conflict of interest is an ineffective assistance of counsel claim. The best procedure for handling such a claim is a collateral post-conviction proceeding after Adelson's appeal is complete. Adelson's motion to relinquish fails to satisfy the holding in Steiger versus State, which requires an allegation and showing of fundamental error. Adelson's conflict of interest argument is no more than a premature claim of ineffective assistance of counsel. While Adelson relies on Meneses for the proposition that appellate courts may relinquish jurisdiction to trial courts so a defendant can pursue a 3.850 claim, the issue in Meneses was a Brady violation, not ineffective consistent assistance of counsel. The Supreme Court of Florida's decision in Steiger versus State cast doubt on whether Adelson can still rely on Meneses to obtain a mid-appeal hearing on an ineffective assistance claim. 40 years after Meneses was decided, the Steiger Court held that ineffective assistance of counsel claims may only be raised on direct appeal in the context of a fundamental error argument. The Steiger Court also held that post-conviction proceeding is the proper vehicle for ineffective assistance claims under Strickland versus Washington. Stub, ineffective, in quotes, ineffective assistance of counsel claims relying upon the less demanding Strickland standard are properly considered upon the, sorry, I lost my place, are properly considered upon filing of a legally sufficient post-conviction motion in the trial court, end quote. Steiger versus State, Florida, 2021. At a minimum, Steiger narrows the holding in Meneses by severely limiting the ineffective assistance of counsel claims that may be raised on direct appeal. Adelson's motion to relinquish fails to meet the requirements of Steiger because the motion does not allege fundamental error. To establish fundamental error, Adelson must demonstrate an error that reached down into the validity of the trial itself to the extent that a verdict of guilty could not have been attained without the assistance of the alleged error. Thus, if Adelson wishes to bring an ineffective assistance of counsel claim on direct appeal, he must allege and demonstrate that Rashbaum's conflict of interest caused the jury to convict Charles Adelson rather than to acquit him. Adelson's motion to relinquish fails to allege or demonstrate that Rashbaum's conflict changed the jury's verdict. Instead, the motion merely claims that Rashbaum's conflict of interest infected Charle Adelson's trial. The Florida Supreme Court's decision in Steiger makes clear that this allegation of infection is insufficient to warrant the relief Adelson seeks under Meneses. At best, Adelson's claim that Rashbaum's conflict infected Charles Adelson's trial alleges, quote, a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different, end quote. Strickland versus Washington, 1984. The Steiger decision requires Adelson to raise the Strickland claim in a collateral post-conviction motion. This court should refuse to exercise discretion to relinquish jurisdiction. The Meneses Court made clear that an appellate court's authority to relinquish jurisdiction is discretionary. Meneses held that the filing in the appellate court of a request to relinquish jurisdiction, however, does not require an appellate court to automatically relinquish jurisdiction to the trial court. The Meneses Court also noted that the appellate court, before relinquishing jurisdiction, may evaluate the grounds for the motion to vacate to determine whether they are frivolous and may decide to relinquish on this basis. Adelson's grounds are speculative and therefore frivolous. Even if this court could relinquish jurisdiction under Meneses, Adelson has given this court no reason to do so. Adelson's motion provides this court with no blueprint for how this case would proceed if placed back in the trial court. At minimum, Adelson's motion should have demonstrated two things. First, that further proceedings in the trial court will reveal that Rashbaum had an actual conflict of interest. Second, Adelson should explain why this conflict of interest claim would not be better addressed in a post-conviction motion. Because Adelson did not raise this conflict of interest claim in the trial court, Adelson cannot raise Rashbaum's conflict of interest on direct appeal unless Rashbaum had an actual conflict of interest. In quotes, in order to establish a violation of the Sixth Amendment, a defendant who raised no objection at trial must demonstrate that an actual conflict of interest adversely affected his lawyer's performance, end quote. And this is from Kyler versus Sullivan in 1980. However, an actual conflict of interest means precisely a conflict that affected counsel's performance, as opposed to a mere theoretical division of loyalties. And this is from Mickens versus Taylor in 2002. Adelson's motion is insufficient because it cites the possibility of conflict of interest, but does not hint at how the conflict prejudiced the outcome of his case. But the, quote, possibility of a conflict is insufficiently to impugn a criminal conviction, end quote. And this is also from Kyler. And the Supreme Court explained the reason for this and how even a trial court's awareness of a potential conflict is insufficient for a Sixth Amendment violation. End quote. The trial court's awareness of a potential conflict neither renders it more likely that the counsel's performance was significantly affected, nor in any other way renders the verdict unreliable, end quote. It's also from Mickens. In fact, a potential conflict can work to a defendant's advantage by ensuring that a jointly represented co-defendant does not cooperate with law enforcement. This is from Dixon versus State, 2000. Such joint representation may provide, in quote, a common defense that gives strength against a common attack, end quote. And this is also from Kyler, and that's quoting another case. All right. Facts for the facts alleged in the facts alleged in Adelson's motions are insufficient to support an ineffective counsel claim, assistance of counsel claim, quote, until a defendant shows that his counsel actively represented conflicting interests. He has not established the constitutional predicate for this claim of ineffective assistance, end quote, again from Kyler. The Florida Supreme Court in State versus Alexis had held that, quote, showing an effect on counsel's performance is essential to showing an actual conflict of interest. A theoretical conflict is almost always present in cases of multiple representation. And that's from 2015. At best, Adelson alleges a theoretical conflict of interest that would be better explored through normal post-conviction claim process. This would allow the lower court to hold a hearing on all of Adelson's post-conviction claims at once. The record contained in Adelson's own appendix shows why Adelson's conflict argument is premature, and therefore his motion should be denied. Both Charles and Donna Adelson waived any conflict arising from Rashbaum, representing both co-defendants during separate trials. But before jury selection, in Donna Adelson's case, Charles Adelson revoked his waiver of the potential conflict. During that jury selection, Attorney Laurel Niles, Charles Adelson's appellate attorney, stated that when they received a subpoena for Charles Adelson's trial testimony, they spoke to him about invoking his rights. Niles recognized that a potential conflict would only arise if Charles Adelson took the stand as a state witness and faced cross-examination from Donna Adelson's attorneys, particularly Rashbaum. Niles stated that, quote, the potential for conflict was always there, but the conflict arose. It's going to arise on the witness stand. It has not quite yet arisen, but a potential for conflict is there, end quote. Thus, even during the hearing, which resulted in Attorney Rashbaum's removal from Donna Adelson's case, Charles Adelson recognized that there was a potential for conflict if he testified, but Charles Adelson did not assert that there was an actual conflict. In his motion to relinquish jurisdiction, Charles Adelson appears to rely on the fact that both the state and Rashbaum listed Donna Adelson as a witness for Charles Adelson's trial. Rashbaum, however, removed Donna from the witness list before Charles Adelson's trial began. Charles Adelson's motion speculates that Donna Adelson's removal from the witness list was done in order to protect Donna Adelson's interest, for example, in not being interviewed by the state. And again, Charles Adelson's interest in parentheses, a witness that could have corroborated Charles Adelson's testimony was not called by Mr. Rashbaum, end quote. And that's also from the motion that they wrote. So this speculative claim is a poor reason to put this appeal on hold and send Charles Adelson's case back to the trial court. Charles Adelson cites an October 12, 2023 motion hearing where attorney Maricel Descalzo appeared on behalf of Donna Adelson, who was then a potential witness in Charles Adelson's trial, alongside her husband, Harvey Adelson. According to attorney Descalzo had concerns about the state seeking to interview Donna and Harvey Adelson. Rashbaum, then representing Charles Adelson, explained to the court that he had included Donna Adelson on his witness list after the state had sought to interview her. Attorney Rashbaum believed that the state had sought to interview Donna as an end run around the discovery rule. Rashbaum complained that the state had years to interview Donna Adelson, but only sought an interview immediately before trial. Rashbaum stated that he would remove Donna from the witness list if she was not going to be interviewed. But Rashbaum added that he listed Donna as a witness as a protection for myself to put them on there, end quote. The court, and so they're quoting all the materials that were in the appendix from the original motion. The court asked if anyone was planning on calling Donna Adelson, and Rashbaum explained that he did not intend on calling Donna Adelson. Rashbaum further accused the state of gamesmanship, claiming that the state did not intend on calling Donna, but instead they were trying to get an interview now on the eve of trial, frankly, to figure out what my defense is, end quote. The prosecutor, Ms. Kappelman, responded to Rashbaum's accusation, stating that Donna and Harvey Adelson had never made themselves available for an interview. Kappelman said that she reached out to the Adelson to, quote, nail down the fact that they were going to invoke their Fifth Amendment right against self-incrimination, end quote. Donna Adelson responded that she was going to invoke the Fifth for pretrial purposes, but not for trial. This response led Kappelman to believe that the Adelsons were going to testify for the defense. Kappelman stated that she was seeking to interview Donna and Harvey Adelson prior to trial to see if they were going to invoke, but she did not know if she would call them because they never made a statement. Therefore, the parties stipulated that neither the state nor the defense would call Donna or Harvey Adelson as a witness. Thus, the record shows that Rashbaum did not remove Donna Adelson from the witness list to protect her interest and thereby undermine Charles Adelson's defense. In fact, attorney Rashbaum had never intended on calling Donna Adelson as a witness. Instead, Rashbaum only listed Donna Adelson as a defense witness when he learned that the state was intending on interviewing her. Rashbaum believed that the state was attempting to avoid discovery and gain insight into Charles Adelson's defense. These facts fail to show that attorney Rashbaum changed his defense strategy to benefit Donna Adelson to the detriment of Charles Adelson. And even if Rashbaum had intended on calling Donna Adelson as a witness, there would be only a conflict if Donna Adelson's defense was detrimental to Charles Adelson's case. And there's no evidence of that. Rashbaum's representation of both Donna and Charles Adelson was no more conflicted than the dual representation at issue in State versus Alexis, Florida, 2015. Alexis and co-defendant Guerriere, I'm sorry, I did not look that up, were represented by the same attorney at trial. So Alexis and her co-defendant were represented by the same attorney at trial. The victim and another witness testified that Alexis, or Grier, I'm sorry, it looks like a French word to me, had pulled the victim out of a car and pointed a gun at him. Grier had made a statement at trial that both he and Alexis had asked the victim to get out of the car, which is occupied by a female friend of theirs, and Alexis had pulled him out of the car. Both defendants testified at trial that they had jointly pulled the victim out of the car, but neither displayed a gun during the encounter. The state had argued that since the co-defendants' respective defenses were compatible rather than conflicting, they both admitted pulling the victim from the car. They both denied being armed, and neither claimed the other was armed. The dual representation did not create a conflict of interest between the respondent and his attorney. The Florida Supreme Court agreed there was no actual conflict of interest. Conclusion: there is no reason to delay this appeal any longer. If Mr. Adelson wants to immediately pursue his post-conviction remedies, Charles Adelson should dismiss this direct appeal. If Adelson does not immediately want to pursue the post-conviction claims, he should continue with his direct appeal and file his post-conviction motion when this appeal concludes. The state asks this court to deny Adelson's motion to relinquish jurisdiction. And this was submitted by Ashley Moody, Attorney General. She was writing for Trisha Meggs Pate, and Trisha evidently is, I believe, the niece of Willie Meggs. So there it is. That's the original. There is one more reply from Offerman on behalf of Charlie, but my throat is not going to take much more of this, so I'm going to have to read that in a second session. So I hope you'd enjoyed this reading. I wanted to read it. I've heard a few analysis about the motion and the response, but I wanted to read it word for word myself so that I could really understand what the conversations were about. And I feel like there are some, there's some legalese in here, but most of this is pretty understandable, plain talk, really, so for all of us. So I hope you feel the same way. And I'm going to go get something hot to drink for my throat. And I hope you're all having a great evening. I just appreciate you joining me tonight, and we'll see you soon.
The crime scene, or very near the crime scene, on your way from your residence to, I guess, to lunch or to wherever you're going next?
No, I did